Ben Chu, Johnny Depp's lawyer from Virginia, has reacted to Blake Lively and her case. This should be interesting. Let's see what we got.
Now, Ben, we haven't talked about this before. And the first question I had is, and we're already seeing this online, there have been a lot of comparisons between this case and the Johnny Depp Amber Heard legal saga that unfolded in 2022. There is a big difference here, practically. We won't have cameras in the courtroom for the proceedings and potentially an upcoming trial for Lively Baldoni, this federal case. But why are we seeing the comparisons? Why are people making the comparisons? And do you think those comparisons ring true?
I think there are some comparisons. You have on both sides, you have prominent actors, which you had also in the Depp case. I think the stakes are a little bit different in this case. In Johnny's case, he was suing for defamation. He was really suing to get his reputation back. It was more of an existential issue for him, a challenge that we had, and I think the other side had, but I think they really have it in this case, is to convince a jury of lay people why they should care about a dispute between two very powerful, successful, attractive actors. And I think that's a challenge, irrespective of the serious nature of the allegations.
That's very true. And look, the allegations that were leveled in Depp v. Heard were very, very different than what we're.
Wait a minute. I think Ben made one serious mistake there. He said there were two high-profile actors in the Depp vs. Heard case, but I think there was only actually one actor, Johnny, and the other, not so much. But that's my silly opinion. Please continue.
So Blake Lively's team was requesting a protective order to essentially prevent Baldoni's team, and maybe more specifically his attorney Brian Friedman, from making public comments about the case. And we're learning that this hasn't necessarily been granted. The judge basically told the parties to follow the rules here. There was initially, it was an idea of let's come up with a protective order by March 11th. But it seems what the judge has said is more specifically, be careful of the out-of-court statements that you make because you don't want to materially prejudice a case. You don't want to taint a jury. What does that mean for these attorneys? What does that mean for Brian Friedman? Will he not do more interviews? Will he not do podcasts? What's the line between speaking publicly about the case and regurgitating what your claims are and what your defenses are versus crossing the line?
Yeah, good question. And the thing is, now that Depp vs. Heard happened, they know the consequences of saying things in public and that coming back to the court in some way, shape, or form, positive or negative. But I'm sure Ben could explain better than me.
Putting aside whether there's a protective or gag order in place, as you well know, you always want to be careful as an attorney to say strident things or to go too far, because even if there's no gag order or protective order in effect, judges tend not to like to see attorneys mouthing off or becoming strident, that there's only one star in a courtroom and that's the judge. Then you have the issue of whether there is a gag order. In my experience, I've been on both sides of this issue. Judges are loath to impose protective orders or gag orders because the very nature of court proceedings is that they are open to the public. And any restriction on speech is anathema. I had one case which I thought we had a very compelling case for a gag order, and the court said, no, at least not now, not until we get closer to trial. Now, as you know, once you get within the proximity of trial, once the jury summonses are going out, judges tend to be more receptive because of what you said a moment ago, which is the danger of tainting the jury pool. So I think as we get closer to the trial date, I think the judge might be more receptive to granting some form of gag order. But when you're out several months from trial, I think most judges tend to be leery of protective orders. Now, there is one protection, and this is the third bucket, I guess, in response to your question. And that is lawyers always have to be careful, and they sometimes forget in their zeal to represent their clients or to promote themselves, they come up with some kind of dramatic quote. And attorneys need to be careful that even in the absence of a gag order, it might upset the judge, or it could even subject them to defamation liability, that they can say almost anything they want to in court, but once you step outside of court, you can be sued for defamation just like anybody else. And that can also get your client sued. It can also get you conflicted.
Right. Excellent points. It's really tough these days keeping everything inside the courtroom, and it seems like it's almost impossible. This makes me think that there's really no perfect system anymore for justice with this type of case when a lot of the people involved are well known, or you could just look them up immediately.
So Baldoni's team, maybe more specifically Brian Friedman, creates this website. They launch it. It's called thelawsuitinfo.com. And posted on this, one is an amended complaint, and the other is an alleged timeline of relevant events that includes a ton of text messages and emails to and from pretty much everyone involved in this case. I thought it was really interesting before Monday, before a hearing, to determine whether you're making inappropriate out-of-court statements and whether or not you might be silenced, to post all of this on a public website for everybody to see. And that's where you list this new amended complaint. I thought that was pretty bold. Well, you think that's a good idea? Wise decision? What do you make of that?
I agree. Bold, aggressive, chutzpah, whatever the right term is. I think it is very aggressive. Usually, you would not do something like that before a hearing, but I'm sure that they vetted it carefully. They vetted the material carefully. Certainly posting a pleading doesn't seem to me to be out of bounds. These are pleadings made in the public records. Whenever you're getting into work product or advocacy pieces, then I think, it's getting closer to the line. So, but it's a novel approach, a bold approach.
So, seems like Ben's thoughts are not very complex on the website there. I guess bold is the right way to put it. Anyway, let me know what you think in the comments. The full video is up at Law and Crime on the YouTube channel. Always nice to see one of Johnny's lawyers pitch in their opinion. Let's hope Camille does the same. If you're not subscribed here, consider it. If you don't, I'll be sad, but I'll get over it. See you next time.